In an increasingly globalized world, love often crosses borders. International marriages, unions between individuals of different nationalities, have become more common than ever. While these relationships can be enriching and beautiful, they come with complex legal implications that many couples are unprepared for. From immigration procedures and dual citizenship to property rights and cultural legal norms, navigating an international marriage requires more than just emotional commitment. It requires legal clarity and foresight. This video explores the top 10 legal considerations couples must understand when entering into an international marriage, whether they plan to live in the US or abroad. 1. Immigration laws and visa requirements. One of the most immediate concerns in an international marriage is determining how both spouses can legally live together in one country. If a U.S. citizen or permanent resident marries a foreign national, the couple must navigate U.S. immigration law to obtain a green card, permanent residency, through marriage. This process involves proving the marriage is genuine, submitting forms like I-130 and I-485, if applying from within the U.S., and attending interviews. Depending on where the foreign spouse resides, different visa types, such as the K-1 fiancé, visa or County Route 1 marriage visa, may be required. Immigration rules differ by country, and failure to comply can result in visa denials or bans, so timely legal guidance is crucial. 2. Validity and recognition of the marriage in different countries. Not all marriages are universally recognized. A marriage that is legal in one country may not automatically be considered valid in another. This becomes particularly important for same-sex couples, religious ceremonies, or civil marriages not registered with a government authority. For example, a civil marriage performed in the U.S. may not be recognized in a country that only acknowledges religious marriages. Couples must ensure that their marriage meets the legal requirements of both countries, particularly if they plan to move, apply for spousal benefits, or petition for immigration status. 3. Proving the marriage is genuine. When applying for immigration benefits based on marriage, especially in the U.S., couples are required to prove that their relationship is bona fide, meaning it is based on love and a shared life, not just to gain immigration benefits. This involves providing evidence such as joint bank accounts, lease agreements, photos, travel records, communication history, and affidavits from friends and family. USCIS and consulates closely scrutinize international marriages for fraud, and inconsistencies or a lack of documentation can lead to application denials or even accusations of misrepresentation. 4. Prenuptial and postnuptial agreements. International couples should seriously consider entering into a prenuptial or postnuptial agreement, particularly if one or both spouses have significant assets, own property in different countries, or wish to protect family inheritances. These agreements can outline what will happen in the event of divorce or death and which countries' laws will apply. Legal systems vary greatly when it comes to property division, so having an agreement that clearly states expectations and jurisdiction can help avoid lengthy, cross-border legal disputes in the future. 5. Taxation and financial obligations. International marriages can complicate tax situations, especially when one spouse is a U.S. citizen or green card holder, as the U.S. taxes its citizens on worldwide income. Couples must decide whether to file taxes jointly or separately and may need to report foreign bank accounts, assets, and income under the Foreign Account Tax Compliance Act, FATCA, and Foreign Bank Account Report, FBAR, rules. Moreover, different countries have tax treaties, and understanding how these treaties apply can help avoid double taxation. Consulting with a tax attorney or international accountant is highly recommended. 6. Name changes and document updates. Changing your name after marriage is relatively straightforward in some countries but complicated in others, especially when trying to update passports, visas, and identification documents across different legal systems. Inconsistent documentation can cause issues when traveling or applying for immigration benefits. It's important to understand each country's process for changing names legally and updating all associated documents, including birth certificates, social security records, bank accounts, and insurance policies. 7. Legal custody and rights of children. When international couples have children, their legal rights and responsibilities can become complex, particularly in cases of separation or divorce. Custody laws differ across borders, and an international parent may face challenges securing parental rights or relocating with a child. In worst-case scenarios, one parent may unlawfully remove the child to another country, triggering international legal conflicts under the Hague Convention on the Civil Aspects of International Child Abduction. Couples should understand each country's custody laws and may want to formalize agreements early to avoid future legal issues. 8. Divorce laws and spousal support across borders. In the unfortunate event of a divorce, international couples must deal with complex legal questions. Which country has jurisdiction? What law will govern asset division and alimony? Can a court decision in one country be enforced in another? Divorce laws can be vastly different. Some countries don't recognize no-fault divorce or enforce spousal support. A couple divorcing across borders may also face legal battles over child custody or property division. Understanding each country's divorce laws and seeking legal advice early can help mitigate emotional and financial stress later. 9. Access to healthcare and social services. The ability of a foreign spouse to access healthcare and other public services depends on their immigration status and local laws. In some countries, spouses on a temporary visa may not be eligible for state-funded healthcare, insurance, or social security benefits. In the U.S., for example, many benefits require lawful permanent resident or citizen status. Couples must understand the legal limitations and explore private insurance or alternative support systems if necessary. It's wise to plan for potential gaps in coverage and access. 10. Citizenship and dual nationality issues. Marriage to a citizen doesn't automatically grant the foreign spouse citizenship. In the U.S., after receiving a green card, a foreign spouse must usually wait 3 years, if still married to a U.S. citizen, before applying for naturalization. Other countries may have different requirements or not allow dual citizenship at all. Before applying for any citizenship, couples should understand the benefits and risks, including potential military obligations, tax exposure, or loss of original citizenship. Consulting with immigration and nationality law experts can clarify what options are available. International marriages can offer rich cultural experiences and a lifetime of love, but they also bring legal complexities that domestic couples may never face. From immigration hurdles to tax considerations, child custody issues, and beyond, a legally informed approach is essential. Early planning, open communication, and the involvement of qualified legal professionals on both sides of the border can help avoid pitfalls and build a strong foundation. Love may know no borders, but the law certainly does, so respecting and understanding those legal lines is the key to a successful international marriage.